Vice President Kamala Harris and President Biden seek to make major changes to the Supreme Court with a change to the U.S. Constitution. In an op-ed today, President Biden is calling for a, quote, constitutional amendment called "No One is Above the Law," stating there is no immunity for crimes a former president committed while in office, and proposes the Supreme Court implement term limits for justices and enforce a binding code of conduct. Let's bring in House Oversight Committee member and Democratic Congressman from New York, Dan Goldman. Congressman Goldman, good to have you with us. Thank you for joining us.
Thank you.
So, it's interesting, going through the op-ed that was written by President Biden, he says there should be no immunity for crimes a former president committed in office. And essentially what the Supreme Court found was that you have immunity for official acts, but not for unofficial acts, and that it would fall to courts on specific instances to determine whether or not those actions that the president committed were official or unofficial. So, I mean, that is not different from the basic understanding that we've had about what the Constitution said on this all along. So why would we need to change it based on the Supreme Court finding?
Well, first of all, that's not entirely right. They said there was a core constitutional powers over which there is absolute immunity. That would, for example, include the pardon power. So if someone were to pay Donald Trump $1 million to get a pardon, he could not be charged for giving that pardon. The other category, which is very expansive in the Supreme Court's language, does refer to the lower courts, what they should find as an official act. But it is very permissive and very expansive. And what I think President Biden is saying is he's saying, hey, I am the president right now. In theory, I could really take advantage of this. I could use it, but I don't want to, because I want to make sure that no one is above the law. So not only am I not going to take advantage of this new immunity, but I'm actually going to try to prevent future presidents from doing it.
I mean, when you go through what they said in this decision, it is not new immunity. The court decided that the nature of presidential power entitles a former president to absolute immunity from criminal prosecution for actions within his conclusive and preclusive constitutional authority. He's also entitled to at least presumptive immunity from prosecution for all his official acts. There is no immunity for unofficial acts. So if a president goes outside his official acts, and there's no determination yet on whether or not former President Trump did that, but that would be for the court to decide. To bring about a change to the Constitution, an amendment would be a huge bar, given the likely construct of Congress. So is this a political statement that he's making, given the unlikelihood that it could ever get through the high bar for an amendment to the Constitution?
Well, I'm going to have to disagree with you that this existed before. It never has. It's never been enumerated. And for example, the Supreme Court did say that any conversations that Donald Trump or a former president would have with his attorney general could not only not be used as charged criminal conduct, but can't even be used as evidence of a larger conspiracy. This is completely new, born out of total whole cloth. And so the notion that this Supreme Court has now protecting Donald Trump, having been packed with 3 Donald Trump judges, is trying to undermine an indictment against him for his efforts to overturn the 2020 election. And Joe Biden is saying, no, that's not okay. No one should be above the law. The president of the United States, nor no one else.
Let me ask you this then, this is an example that obviously is a painful example from the exit from Afghanistan. Could those families whose service members were killed at Abbey Gate, could they sue the president for recklessly carrying out his roles as commander-in-chief, if that were their opinion and that were their legal argument? Could they do that?
Well, no, there's no cause of action because of qualified immunity for those civil decisions. But even if you were to try to charge someone for a criminal action, you'd have to show that there was a conspiracy and an intent to violate the law and commit a crime. And it's the same argument that, unfortunately, my colleagues on the Republican side make about Secretary Mayorkas, as if the fact that there are migrants coming across the country who may commit crimes, and by the way, they commit far less crimes than Americans, that somehow he is complicit or an accomplice to those crimes. That is bogus. That is not how our criminal law works.
Well,
there are many protections to ensure that someone is not charged.
Right, and to decide what is an official and what is an unofficial
there are protections
act.
by beyond a reasonable doubt, by evidence, by having to prove mens rea, criminal intent.
That's right. All those things were already in the law and already understood. Exactly. And
right. So why does anyone need immunity?
I'm not sure why we need an amendment, is what I'm saying, based on the way that the government has functioned around presidential powers up until now. But let me ask you a quick question about term limits. You say that President Trump packed the court with 3 conservative justices. Now, it's interesting because Gorsuch and Kavanaugh have disagreed on many different cases. They also enacted the ability to protect the right for people to use mifepristone, which is an abortion drug. So they're not in lockstep at all. And to suggest that he packed the court when he had 3 opportunities to nominate someone to the court isn't packing the court. It's just using your presidential your ability that when one justice leaves, you get to nominate someone.
Well, let's remember how he was able to nominate his first justice, which was that Mitch McConnell in the Senate refused to give a hearing to Merrick Garland for over 9 months, which was absolutely preposterous.
But that didn't have anything to do with President Trump.
At the tail end of well, that's how he got his first one.
Well,
then
I mean,
at the end of his term,
he had nothing to do with that when it happened, so he benefited from it. But go ahead.
Well, I'm ultimately addressing the term limits, because at the end of his term, they then rammed through Amy Coney Barrett in the span of 3 weeks, which was a completely different standard than what they used for Merrick Garland. The point of this 18-year term limit, to be done every 2 years, is that it would take the timing out of this process, and it would be much more regularized. It would allow whoever is president to have exactly the same number of appointments, so that this is no longer an effort to squeeze in an appointment or to retire because it's the right president, so I can be renominated, someone else to replace me. This would be much more regimented and routinized, so that we can take out a lot of these partisan shenanigans and just make sure that we have a fully settled process.
Well, it's not without support, this idea, in the polls. You know, we've had decades of liberal courts, we've had decades of conservative courts in the system that we have. So I think it's going to be very interesting to see the debate over all of this over the next 3 months. Representative Goldman, thank you very much. It's good to have you here, sir.
Thank you.
Hey everyone, I'm Emily Campagno. Catch me and my co-hosts Harris Faulkner and Kaylee McEnany on Outnumbered every weekday at 12 p.m. Eastern, or set your DVR. Also, don't forget to subscribe to the Fox News YouTube page for daily highlights.